The best lessons in life are often learned outside of the classroom. That's where all the action happens. That's where the rubber meets the road and the hard knocks knock some sense into you. But did you ever wish you could get those lessons without all the fuss? Sign up today and get your first week free. You can cancel at any time.
Hi, I'm Rick Brimacombe from Brimacombe Capital on behalf of Lessons from the Garage. Welcome to our July podcast, Basic Legal Issues for Entrepreneurs. Lessons from the Garage provides learning for entrepreneurs. Think of Netflix for business owners and leaders trying to grow their companies. There are over 200 videos with about 300 by year end, and you can go to the website www.lessonsfromthegarage.com and sign up for a free 7-day trial and check it out. Lessons from the Garage is powered by the Network Connect. The Network Connect is a platform created to connect investors, companies, and preferred service providers, as well as act as a catalytic gateway to fuel business growth. To learn more about us, you can go to www.thenetworkconnect.com. Our events and contacts have helped companies raise millions of dollars, and our monthly newsletter reaches thousands of investors as well as tens of thousands of business contacts. Before we get to today's podcast, I'd like to first say thank you to our sponsors, Monroe, Moxness, and Berg. For over 30 years, many of America's best-known concept and emerging brands, as well as businesses and residents of Minnesota and neighboring states, have relied on Monroe, Moxness, and Berg for legal and financial acumen in business law, finance, mergers and acquisitions, intellectual property, franchise and distribution, estate planning and financial planning, as well as taxation, wealth preservation, real estate, land use, employment, and commercial litigation. Learn more about them at www.mmblawfirm.com. Again, that's www.mmblawfirm.com. Schwegman Lundberg Woosner, otherwise known as SLW, is an internationally recognized intellectual property law firm providing patent and trademark and other IP-related services. They are also a sponsor of today's event. You can find out more about them at www.slwip.com. So thank you very much to our sponsors, our genuine sponsors, Monroe, Moxness, and Berg, as well as Schwegman Lundberg Woosner. Events like this wouldn't happen without their generous support, and to the extent you can, please support them. They've been very supportive of us and therefore supportive of you. So reach out when you can. If you'd like to learn more about sponsorship opportunities with Lessons from the Garage, please reach on out to us. A couple of last announcements. Again, Lessons from the Garage is like Netflix for entrepreneurs and business owners trying to grow their companies. There's a 7-day free trial if you'd like to check it out. The Network Connect website, thenetworkconnect.com, has a schedule of events that you can sign up for, as well as sign up for the newsletter and get access to a variety of information and events. As far as our webinars go, next month we're going to be talking to an investor. That would be our August webinar. And then in September we're going to be covering accounting. So that gets us up to today's panel discussion, Basic Legal Issues for Entrepreneurs. Transforming an original idea into a tangible business enterprise is an exciting process, but along the way comes an array of legal issues for entrepreneurs to confront and address. To help you anticipate and prepare for them, the podcast today will address 3 main issues of concern. Securing the right kind of financing, what sources of funding and securities and law exemptions are available once you move beyond friends and families, protecting your idea to ensure its confidentiality, as well as what you can do to secure trademarks, copyrights, and patent protection. And lastly, although it actually starts at the front end, forming your business entity, what types of structures are available and what tax benefits may apply. We have 3 different speakers with us today, as you can see. To my immediate right is Brian Tunis. Brian is an associate at Monroe, Moxness, and Berg. He advises business owners on matters related to establishment and reorganization, structure, operation, and tax reporting requirements for businesses. I'd also like to mention that Brian likes to brew beer in his spare time, a very critical component of this discussion today. Joshua Mason, to my right, is associate at Moxness, Monroe, Moxness, and Berg. He helps entrepreneurs and private companies and small business owners protect their concepts and brands. He advises clients on a number of IP issues, and tying into the theme of brewing and craft beers and having fun. He published a piece on the business models of brew pubs versus tap rooms, and who doesn't want to know the difference between those two kinds of business models. Lots of good due diligence to perform there, and I'm sure Joshua did a great job with that. John Raymakel is a shareholder at the law firm, and he advises private companies and small business owners on a wide range of transactional, corporate finance, and business law matters. He leads the firm's securities law practice and focuses on representing startups as well as emerging companies in all aspects of equity and debt financings. A little side note for John, he's on the board of the Twin Cities Men's Adult Baseball League. So for a little summer activity here, we're mixing beer and baseball, good combination. So thank you, John, for joining us, Joshua and Brian. And with that, I will turn it over to them. We'll have 5 to 10 minutes with each one of our speakers. We'll get to some Q&A and have a good conversation today to bring you up to speed on all the legal matters that it takes for you to grow your business. So with that, Brian, why don't you kick us off?
All right. Thanks, Rick. So you have your business idea. You want to start your business. The first question you might be asking yourself is what kind of entity you should set up for your business. I like to think there's 3 general types of business structures. The first is a sole proprietorship. Second would be pass-through type entities like LLCs, S corporations. A third would be corporations. And I'm going to go through each of the 3 of those. Sole proprietorship, it's the simplest way to start a business. It might be what you think of when you just go out and start doing business under your own name. It's a business owned and operated by one person. It's not a separate legal entity from the individual. All income from a sole proprietorship flows right through to the individual. It's taxed right to them. A major advantage of a sole proprietorship, it's cheap. You just go out and start conducting your business. There's no filing to be done unless you're going to do some sort of assumed name or something like that. A major disadvantage, there's no limitation on liability or no liability protection that for a sole proprietorship like you would have with a limited liability company or an S corporation or a corporation. Generally don't recommend sole proprietorships very often, and a little bit later I'll say a little bit about when I would recommend one. But let's move to pass-through entities. Pass-through entities, they're called pass-through entities because the income and losses for these entities pass right through to the owners. These entities can be partnerships, limited liability companies, S corporations. And the nice thing about these types of entities is they can be set up, they are set up as separate legal entities from their owners. They can be set up in a way to limit liability for their owners. For example, as a partnership, you could set up as a limited liability partnership. LLCs and S corporations are inherently protective of their owners. So that would be a major advantage to this type of business. The disadvantage to one of these compared to a sole proprietorship, it's more costly. You have to file some kind of filing with the state wherever you're organized to set these type of entities up. Depending on the structure, the number of owners, the complexity of the entity itself, the legal work and accounting work is going to be more costly and possibly substantially more costly than a sole proprietorship. And then the third type of entity is a corporation. Corporation is not a pass-through entity like the other entities were. And when I say that, I mean a corporation is subject to double taxation. Income through a corporation is taxed once at the corporate level and once again when it's distributed to shareholders. The corporation, like the LLC and S corp, is a separate legal entity, and it provides excellent liability protection for its individual owners. So then the question we get asked a lot is what type of entity would you suggest for a new business owner? Short answer: it depends. It really does depend on on your specific situation. Depends on the number of owners of the business, the complexity of the agreement between the owners, source of funding for the business, and John will talk about funding a little bit later. But usually don't recommend sole proprietorships due to the unlimited personal liability concerns for the owners. However, a sole proprietorship may make sense in limited situations where you want to have an inexpensive start to a business. It's not going to be a huge business necessarily, or it's something that has very limited legal exposure, limited liability exposure, and for which you can get insurance and mitigate that exposure. More often than not, I'm going to recommend an LLC. As I noted earlier, well, I didn't note it earlier, but LLCs are extremely flexible entities. They can be adapted for just about every business situation. If you have multiple owners or investors, the LLC would be a starting point to look at and kind of work backwards from there if it doesn't fit your need. I may recommend a corporation in a few certain situations. And we could talk about the tax benefits of each one, and that'll lead into why I would recommend a corporation over an LLC. So the other part of this presentation is the tax benefits from each of these entities. One of the major reasons we suggest LLCs over corporations, for example, are the income and losses for an LLC pass through to the owner. This means the owner gets to pay the tax on the income from the entity, but they also can use the losses from that entity to offset their income. In addition, following the 2018 tax reform, LLC business income and other pass-through business income is subject to an additional 20% deduction, up to a 20% deduction on business income. For LLC owners that can make use of this full 20% deduction, it makes the LLC hard to beat tax-wise as far as entities go. It's going to beat a corporation majority of the time. It's going to be the most tax-efficient vehicle you can use. And that is with one caveat. Corporations are now taxed at 21% as a flat corporate tax rate. Given this low, comparatively low tax rate, if a corporation's income is only taxed one time, and before I said it's subject to double taxation, once at the corporate level and once when it's distributed. So if it's only taxed at the corporate level and income is never distributed, it's retained by the entity for a substantial period of time, a corporation may be your most tax efficient vehicle because it is only taxed once. It's at a very favorable 21% tax rate. So to recap where we've been through, sole proprietorships are tough to recommend given the lack of liability protection. LLCs, great, highly flexible business vehicles, can be used and adapted for most situations. Generally the most tax favorable business entity, and would generally recommend your search to start, first search for a proper business vehicle to start with an LLC and work from there. Corporations offer excellent liability protection, are great for accepting outside investments, but are not necessarily the most tax efficient business structure outside of those situations where income and earnings are retained in the corporation indefinitely or for a substantial period of time. But going back to the fact that these are highly fact-specific determinations, your choice of entity should be made upon consultation with your legal and accounting advisors who know your specific situation.
Couple of quick questions. Oftentimes, folks that are thinking of starting a new entity might be employed somewhere else. Talk a little bit about when they should set up a new entity and kind of that transition of, hey, when do I quit and when do I start this, and maybe go through that just real briefly. Or is that too big of a can of worms?
It's a little broad. We can talk about, you can set up the entity. If it's just you setting up a new business, you can set up an entity at any point. You're not going to trigger anybody. Nobody's searching entities every day. Nobody's going to know you set up this entity. They're not going to know what you're doing with it. You can do that. You can get with your advisors. You can get all the documentation in place, get your business plan ready to go, and then once everything's ready to launch would be the time to do that.
And sometimes your employer might have a non-compete in place with you that you have to consider also, whether your new business would potentially trip up a non-compete, create an issue. We see that especially in medical device or health law areas, technology. A lot of employers in those spaces, especially if folks are involved in sales or intellectual property development, will have a non-compete that they have to consider. And if they're starting up a new business that's in the same area that they're breaking away from.
And are typically, if you're looking at a pie chart, just the raw number of new entities that get started, is the LLC kind of the most common vehicle?
That we see, I would say LLCs are probably the most prevalent. My guess is there's probably more sole proprietorships than LLCs and whatnot, but those folks don't tend to.
The Minnesota Secretary of State publishes now and then the number of entities formed, at least in Minnesota, and I think the last time I saw it was about, and don't know the exact number, but it's close to 80% are LLCs. And probably the other 20% are mostly, I would say, probably corporations or other partnerships.
And then oftentimes a business matures and you take in outside investors, and many times those investors want the company to be a C Corp. Talk about transitioning from an LLC to a C Corp and how difficult is that?
Yeah, transitioning, switching from an LLC to a C Corp, yeah. The big concern I would have there is the tax implications, because you're going from an entity that's been a pass-through entity, everything's going through to the owners, to an entity where it's taxed at the corporate level. Yep. But it's it's better to go from an LLC to a corporation than the other way around, where you've been retained. So there's not as big of a concern there. Okay. As far as the actual conversion itself, it's I believe it's just a state filing. It's not a super complicated concern. Right. Yeah.
And then what about the number of members that an LLC can have? Does it get legally kind of unruly once you get up to a certain number? Is the LLC best utilized for a smaller number?
Yeah. So for tax returns every year, LLC owners are going to get a K-1. Mm-hmm. That can get a little unruly when you have so many investors that your accountants are going crazy just trying to get all these K-1s put together. John, what would you say as far of a kind of a general cutoff?
Threshold?
Yeah.
I think it really depends on who your investors are, especially if they're sophisticated venture capital firms, or they're going to definitely force you into a corporation immediately before they even invest. That'll be part of the Series A round. So I don't think I wouldn't necessarily shy away from starting out as a LLC. I think, as Brian mentioned, it's a pretty simple conversion from a state law perspective. You're going to need a conversion agreement with your shareholder or your members. Then they become shareholders. You'll probably have to get a transfer agent to put together stock certificates, depending on the number of shareholders I guess you will have, but it's a relatively simple, easy process.
Yeah, and Rick, to address your question about number of LLC members and complexity of issues to be taking into consideration, I think there's a big jump from 1 to 2 even. You can have a single member LLC, and that's just you as a business owner. You're the single member of that LLC. You have one other person. You have to start thinking about what happens when a disagreement about the direction of the business arises, a disagreement about distributions, who's entitled to what and who has what authority, how do you unwind the business, and so even just jumping to two members, you have all of those considerations that you have to think about. So there's even just going to 2 members adds to the complexity of that consideration.
Okay. All right, Joshua, let's stay with you and move on to our next category. Talk a little bit about protecting your idea and other components of intellectual property.
Yeah, absolutely. And thanks for your introduction, Rick, and thanks for having us here today. So I'm just going to talk about some intellectual property issues, primarily trademark. Want to cover a couple basic topics, sort of frequently asked questions that I encounter in my practice, from things like, what is a trademark? How is it different from other types of intellectual property protection I can get, like a copyright or a patent? Do I need to get a trademark registration, and how do I do it? And other common questions I get, like use of the registered trademark symbol, and questions about when you can use a trademark if you think there's something that's similar out there and you think that your business is different enough to permit use of that trademark. So those are some common questions I get
Okay.
On trademark and intellectual property topics. So kind of to start from the beginning, what is a trademark? It's really it's as simple as a word, a symbol, or a device. And it's meant to distinguish your product or your service, but it also can identify the source of the origin of your product or service, and also meant to symbolize the quality of that good or service and your business. How is it different from, say, a copyright or a patent? There are a couple key criteria that make these different. First off is just what is subject to those different protections. Like I said, a trademark is a word, a device, a symbol. Patent would cover things like a novel, a song, lyric, music, articles, other works of written authorship. Sorry, I flip-flopped that. Those items would be covered by copyright, excuse me. And a patent would cover a novel in the sense of unusual, unknown, new, and unique, non-obvious invention. So trademark is word, symbol, devices. Copyrights are works of authorship. Patents are non-obvious, novel inventions. There are some differences in how long each of those is subject to formal intellectual property protection. A patent is generally available for only 20 years. Copyright can last for the life of the author, plus 70 years in some cases. And a trademark registration initially is valid for 10 years with some required maintenance filings that come up around the 5th and 6th year. And then there are unlimited renewals available after that every 10 years. And so the real difference between those types of intellectual property is really what it protects first off, and what protections it provides. Another question I get a lot is a trademark registration required? Do I need one? Do I need a registration before I use the mark I have in mind? The answer is no. A registration does provide very specific benefits, and I'll go through those in a little bit. But you can accrue trademark rights simply by using your mark in commerce. So those are called common law trademark rights, and the law will protect your rights to those marks to a certain extent just by the fact of your use of that mark in commerce. And also, short of a federal trademark registration, there's also a state level process in all 50 states where you can obtain a state registration, and that would have a more limited geographic scope, but also be a much simpler, more streamlined filing process, probably be less expensive for folks who are looking at protecting something on a more limited basis. Registration isn't required, but there are also short of registration steps that folks can take to protect their mark, and also be a little efficient with their budget, right? So I recommend when clients are evaluating a potential trademark, they look into things like available domain names, social media handles, and just take steps to stake a claim to that mark or that brand. And it can be by doing something as simple as throwing a notice on their website or on any of their marketing materials that says, this trademark is the property of my company. And that provides people who are encountering your business with notice that you have a proprietary claim to that mark that you're using. So lessons from the garage, right? There are things that you can do short of incurring the fees to obtain a registration that will allow you to protect your information and your brand as you're starting your business. That said, there are several very significant benefits to registration. First is that you can use the Circle R mark. If you don't have a federal registration, the Circle R mark is not available for your use. You also then have the ability to file suit for monetary remedies, including infringers' profits, costs, and damages and attorney's fees in federal court. Your registration would then also serve as a bar to any other potentially confusingly similar marks that are out there on the market, which is one of the key protections. You'd get the benefit of several statutory presumptions in your favor as well as a registration holder. The law would essentially assume that you are the proper owner of that trademark, that your use has been exclusive, that all other users out there, potential users, are constructively on notice of your right to that trademark by the fact of your registration, even if they didn't actually know that you had a registration, weren't aware that you had obtained one. The law will apply constructive notice to them, and you'll have the benefit of the doubt that they had to know your trademark was in place. And a key benefit here is also that it creates a presumption of nationwide use. So there is an interstate commerce requirement to obtaining a trademark. And so for smaller businesses with a very limited geographic scope, this is something to take into consideration. A federal trademark might not be available to everyone, but there are exemptions and precedent that help provide certainty that even for some certain smaller businesses that are still engaging in commerce, generally online businesses, reaching out to clients in multiple states, customers or clients in multiple states, then even if you're only in a few states or 2 states or 3 states, if you have a registration, you're getting nationwide protection. So if you've got a small Midwest regional company and you've got a brand and you're investing in it, you'll have protection against companies forming out on the coasts, companies forming in the South. They might not have heard of you, but you've got a federal registration, you have presumed nationwide protection. So there are some significant benefits to registering your trademark, but again, on the flip side, there are things you can do short of getting a registration that allow you to protect your property. Another key benefit, and I'll maybe use this as a segue to John here as well, unless Rick, you have other items you want to jump in.
When you're done, I got a couple of questions I'm going to ask.
Yeah, so just one other thing to keep in mind is that as investors are evaluating your business, one of the things will be taking a look at your intellectual property portfolio. What have you done to protect it? What have you done to invest in it? And John, I think you'll attest to that fact as well, that that'll be a key consideration that investors will be looking at when they're looking at putting money into your business.
Can be a deal killer. I mean, you watch Shark Tank, and one of the things Mark Cuban and Damon George and others ask for is and oftentimes the contestants will bring their patent paperwork for some of their inventions and products that they're trying to get investments in. So, and that's absolutely the reality in the VC and private equity space. Is that's going to be if that's your business as an idea, that's absolutely going to be critical.
Yeah. If your brand is your value or your idea is your value, you're going to need to show that you've invested in protecting it and have the ability to protect it. Otherwise, those investors don't know that their investment will be secure.
Okay. Probably the most common question I hear about patents is whether or not somebody should pursue that patent. And obviously, it takes a lot of time and a lot of money, and in many companies, those things are limited. Is there kind of a quick and dirty way that they can come to a conclusion whether or not they should pursue a patent, either on their own or calling you and kind of wading into the pool as opposed to jumping into the pool head first?
Right. Yeah, I think that's a good question. I personally am not a patent attorney that
Okay.
requires a specific educational
Okay.
background and
Okay.
license to practice in front of the patent bar. My intellectual property practice focuses primarily on trademarks and
Okay.
licensing
Okay.
work. But if someone who's evaluating that question, I would recommend that they first of all keep in mind the confidentiality of their idea. One of the requirements for patentability is that the invention is novel, and if your invention has been publicly disclosed, that can pose a serious obstacle to establishing the novelty of your invention. So you have to, if you think you have a valuable invention idea, you have to think carefully about who you're talking to, and how you're disclosing that. And in that instance, contacting a lawyer is obviously a good idea. Putting in place confidentiality or non-disclosure agreements before you're talking about your invention is a helpful step. And then, I would recommend that in terms of evaluating that process and working through that that train of thought, reach out to a patent attorney to discuss on the front end, sort of, likelihood of obtaining a patent and what that process looks like.
So on the trademark front, my observation with many entrepreneurs is that they underestimate the value of trademarks and that they don't pursue those as often as they should, because from my perspective and having seen this many, many times, the ROI kick, if you will, from having a nice trademark portfolio and good brand coverage is really worth the time and effort in most instances. Let's talk a little bit about kind of the ROI or the financial benefit for going through that.
Yeah, and so your question sort of brings a topic to mind that I think doesn't always get talked about as much, and it's that trademark is both it has offensive and defensive aspects.
Yep.
When you obtain a registration for your mark, you're preventing others from using your mark. You're making an exclusive claim to the use of that mark going forward, and that's sort of the offensive consideration. You'll have the ability to prevent others from doing what you're doing. But on the flip side, the more conservative defensive use of the trademark, which I think in terms of this ROI assessment and cost-benefit analysis is maybe even the key. You may be not worried about folks in other states using your mark or something similar, but you are going to be worried if you get a letter one day from a large company that says, we have a registration and your mark that you're using on your packaging and on your website infringes our rights, and you have 30 days to stop using all of those. And that's where I think the ROI really kicks in. You could spend the time and the money to work with an attorney to obtain a registration. That'll be an upfront investment on your part, but once you have that registration, you're going to have that level of assurance going forward that you're not going to unwind the work that you put in place into your business. You're not going to have to rebrand. You're not going to have to relabel your products. And so maybe that's not something that shows through as immediately on the balance sheet in terms of profits and losses, but there's real long-term value to the security of your business by having those protections.
So what's the first step for an entrepreneur or business owner regarding trademarks and interacting with you?
Yeah. So I think the first step is just assessing the strength of the brand or the trademark. And there are really two main aspects to that. I would normally work with folks who are looking at launching a new brand on assessing what's out there in terms of registrations and also common law uses. You know, there are a lot of folks out there generating ideas, starting companies, thinking of brands. Sometimes it can be hard to find a space that your brand, your company fits in comfortably. You mentioned that, John and I wrote this craft brewery article. We do a lot of work in the craft brew space as well. And, that's one area in particular where folks have a hard time finding a good place for their brand because there's so many companies out there protecting different flavors, protecting their house brand, and it's hard to find some free space to establish your brand. So working with a trademark attorney to conduct a search, suggest alternatives or alterations to the ideas you have in mind. I know a lot of folks come to me and they have their heart set on, this is my name, I've got to have it. But sometimes the search results come back and it doesn't look good. Sure. And so thinking through that process, what are other options on the front end, is always better than having to address the issue later on.
Sure.
When you find out that the rights you thought you had aren't as strong or don't exist because someone has prior rights out there. Another aspect of the assessment of a brand is just more on the sort of legal side, considering the protectability of specific trademarks. I'll have clients look at whether or not their marks are overly descriptive of their goods and services. That's one key obstacle that folks face all the time when looking at their brands. There's a bar against registering trademarks that are merely descriptive of the goods and services covered. So just for a very basic example, if you have a company and you want to call it the Minneapolis Chair Company, well, you're based out of Minneapolis. A geographic descriptor is just descriptive of your business generally. Chairs describes the goods and services you provide. You sell and repair chairs in your company. That describes your legal entity status. And so none of the aspects of that potential trademark have non-descriptive meaning that would accrue trademark protection under federal trademark law. And even just adding those types of things at the end, I'm XYZ Chair Company, I'm XYZ of Minnesota, it doesn't help because those non-descriptive elements aren't recognized as protectable under the trademark law. Right. So that's another aspect of the initial process in terms of looking at, are there other conflicts out there, and then this mark as it stands, does it meet registration criteria? And that's something that a trademark attorney can help.
All right. Great. Thanks, Joshua. I appreciate it very much. John, let's shift gears to the different forms of financing. Think of the quote from the movie, "Show me the money." So that's always the most important part of the conversation here, to some respect, saving best for last. Mm-hmm. So tell us a little bit about the different forms of financing and what happens kind of once somebody moves beyond the friends and family realm.
Sure. And this kind of dovetails nicely. Brian covered kind of the entity formation, the very early stage building blocks of forming an entity, and then Joshua covered protecting the idea and the name and the brand. You need all of those kind of foundational items in place in order to attract money. I like to think of raising money on a continuum. There's debt financing from traditional commercial banks. That can be very difficult for small and emerging businesses to obtain. They really have to show strong earnings and profitability before a lot of lenders will make a traditional loan to them. So that that creates a big gap on. You have a lot of small businesses and startups and emerging companies that can be very high quality that just are not bankable. The banks will certainly, you can do a lot of cash type of transactions and depository working line with them, but when it comes to getting term loans and large financings done, it can be difficult if you're not a mature high collateral type of business. So the next kind of step is an SBA loan. The federal government's set up a couple of different programs that are extremely common, and a lot of clients take advantage of those. There's a Section 7A loan, which would be more towards working capital needs, commercial real estate purchasing, equipment purchasing. You can even refinance debt or buy a business using a Section 7A loan. Those loans oftentimes they're up to $5 million in terms of the amount that you can borrow. They take a while to go through the paperwork with the SBA. You're going to have to find a sponsor bank to also, and the SBA is going to backstop, guarantee up to potentially 85% of that loan, and that makes it a creditable asset for a bank to hold, because their exposure is brought down. So that makes you, with the government's backing, that makes you potentially bankable at that point for a loan. The other is a Section 504 loan. We see that more with real estate. It's oftentimes buying a building or purchasing land or doing leasehold improvements, constructing a new facility, and that loan also, the SBA, there's no maximum, but the SBA is only going to fund up to $5 million. So you're somewhat capped there as well. And then you would also need a CDC, a Community Development Corporation, to also be involved in that process. But the SBA is a great program. You're going to have to get guarantor support potentially for for all of those loans. So you're personally going to the owners are personally going to have to sign off on and be liable for those debts. And sometimes major investors are also asked to provide guarantor support. If you aren't in SBA land, or you need more money, or that timing doesn't necessarily work for you, or you don't want to take debt on your balance sheet, then the traditional private placement, raising money from, and we're talking beyond friends and family, so we're getting into angel investors, private family offices are becoming more and more popular. Venture capital firms, private equity groups, even insurance companies and hedge funds sometimes make investments, or foundations make investments, private investments. In that realm, the securities laws become critical, and complying with them and finding an exemption, because anytime you're selling securities, whether it could be common preferred stock or LLC interests, like Brian was mentioning, if the entity is an LLC, you're going to need to either register those securities with the SEC or a state agency, or find an exemption under the securities laws that allows you to do a private placement where you do not have to register the securities. And that's the Regulation D has traditionally been the main exemption that small emerging businesses have relied on. And I don't want to get into an alphabet soup of all the different exemptions, but 506B, 506C, 504, those are all rules under the Securities Act that are available potentially. And oftentimes, as small emerging businesses know, you're going to have to find mostly probably accredited investors, the high net individuals. The rules are $200,000. Somebody has to either make with their spouse an income, or with their spouse it's $300,000. Individually $200,000, $300,000 with a spouse for the last 2 years, and with the expectation that you will be again making that in the next year, or $1 million net worth excluding personal residence. And that really limits the universe of those folks. I think the SEC publishes how many accredited investors are out there, and I think it's generally hovered between 8 to 10% of the U.S. population falls in that. So you're going to have to hang around a lot of golf courses. You're going to have to you're going to have to be in some social circles that really are high net type of folks, or a really good avenue is to be involved with a Network Connect type of organization that brings high net angel people together with these emerging small businesses that need that growth capital. And then in between that, there's different hybrids. So preferred stock can oftentimes look like debt, where it has a coupon, a annual guaranteed return that you may convert later and may accrue and convert later into more stock, or convertible notes. I do a lot of those. Convertible notes are nice because it's kind of a bridge. If you're going to go out with a private placement of $1 million, $2 million, $5 million, whatever it is, it may be difficult to set a valuation of what your company is worth at that point. You have to, the market will tell you what it's worth. It's basically what you can sell it for, but setting that number is more, art than science. And convertible notes are nice. I'd say probably more of a $500,000, $1 million. Sometimes I see a $2 million convertible note raise, depending on the company's size and scope. But the nice thing about those is they punt on the valuation. They basically they say, we're going to give you a loan. The note's going to be convertible at a future date, maybe 2 years maturity, or when the next large investment comes in from a strategic or from a venture capital firm. At that point, the convertible notes will be converted at a discount, 20%, usually 30% discount off of the next round. The next round will set the pricing. The convertible notes, for the risk that the investor took having a convertible note for a couple of years, they get a discount on the pricing of the next round. So that's the kind of continuum of what we see, and helping our entrepreneur and small business clients to navigate what makes most sense for them in terms of debt or equity is one of the things that we're involved with. We encourage having, I think, some of the most successful offerings. Always, I think the client, the company issuer is involving a nice team. They got business consultants or advisors, coaches, like the Network Connect group, or they also have an accounting firm. They have a law firm, a lawyer involved that has experience in capital raising, and they rely on that team to kind of provide and help them through the process, because it can be difficult and can take time. Can be time consuming, and when sometimes inventors need to be focused, or business owners need to be focused mainly on the company that they're trying to grow, and they take their eye off the ball trying to raise money. So leverage your partners, I think, is a good piece of advice. Have a really strong business plan. Pro forma, know your numbers, have pro forma, historical, all pulled together and be able to speak to it. Those are all, I think, pieces of advice that I would give to anybody trying to raise money.
Sure. You mentioned a little bit in passing the timing. Obviously, somebody decides they're going to raise money. It doesn't just happen overnight. So the fundraising itself might take 3 months, best case, 12, 18 months, worst case, but then there's also a chunk of time on kind of getting ready from a legal perspective. Talk a little bit about the time that you would like. So I come to you, I'm a business owner, entrepreneur, I want to raise money. Walk me through kind of the timing of the first part. working with you to get ready to go out to raise the money.
Yeah, and I have a really detailed schedule, which I wish I had here, but where I try to keep.
Well, they'll call you for that.
They'll call
so,
me, yeah. So they can call me for that, but it's got a very to-do list kind of approach. And I think between when they call me and when we have a private placement memorandum, a set of organizational documents that are going to have to be probably reworked a little bit for the next financing round, it's usually, I would say 45 to 60 days is a realistic time period, and there's tasks for each step of the way through that, and then they're off trying to sell it.
Sure.
And,
Yep.
and that's, so, you know, I try to be as efficient, need to be as efficient as possible, because if they call me, oftentimes they needed the money yesterday. They don't, if you can get ahead of it and really involve your advisors, you know, from the conception to the extent you can afford us, you know, it's helpful to have, you know, that contact throughout and keep a nice network, so you're not scrambling to find a lawyer, you're not scrambling to find an accountant, you're not, you have a good base of a talent around you and a good timeline and game plan, and you're keeping them apprised as these events come up. And oftentimes, why is the money needed is going to be a question that you know, that I always raise with them. And do you need to build a prototype to take it to, if you have a product, you need to build a prototype to take it to some show or some, you know, to pitch it to customers, and you need to invest in some R&D. If you have a retail footprint, are you building out additional stores? There's, you know, all of that, it kind of has to go in hand with the fundraising. And so that understanding where you are from a business perspective and why you need the money, I think is a critical first step too.
Sure. You talked a little bit about valuations. I guess in my experience, one of the most common mistakes entrepreneurs make, and it's understandable, of course, is overvaluing the company. They go to market with the valuation up here. They're kind of DOA in the sense of they reach out to folks and the valuation's inappropriate and they get thrown into the circular file and investors go on to the next. What's your advice and counsel to entrepreneurs who come to you and they say, hey, I don't know how to value my company? How do you help them in that instance, and where would you steer them?
Yeah, I think that's again where your network is going to be critical. Do you have a few angels that you know that you can you know, get there, because they have a good sense. They've made investments before. They can look at numbers. Oftentimes they've sold a business or they were in the business world, and they can give you very matter-of-fact advice whether they would invest in it. So sometimes you do a little bit of a soft kind of sell beforehand to the extent you can under the securities laws. You need to talk to me about that. But you should pitch it to some kind of investor types that can, or who have made investments before. Like I said, consultants like Network Connect are really good to tell you whether you have a realistic pro forma, your valuation is in the ballpark, and you're not sky high with it, you know, and being realistic, I think, is critical, because once you approach a group with whatever you think the valuation is, that's probably your only chance, your only bite at the apple, because they are getting flooded with opportunities you know, to invest, and probably only look at your set of materials once.
Yep, I agree, 100%. All right, thank you very much, John. Why don't we aim towards a close with a little bit of summary, kind of wrap things up. So if you say, all right, what are kind of the high points, key learnings, nuggets of wisdom that you'd like to share? And I don't know, I guess since we've been down here talking to you, John, why don't we start there and kind of work backward? So again, just to kind of wrap everything up for our listeners.
Sure. I think management team is critical. Also, in addition to advisors, making sure that you are surrounded by, as an entrepreneur or an owner, making sure you're surrounded by other talented people in your organization that you're creating, is because that's one of the things that investors, they're going to want to sit down with you They don't want to talk to probably some type of investment banker or broker who's trying to sell your concept. They want to talk to the absolute individual, the founder. They want to look you in the white of your eyes and know that you are going to be committed to what they are investing in. And they want to know that it's not just you. There's risk to them if it's just one person. They want to see a team behind you. They want to see that you're starting to think about succession planning. You're thinking about promoting people to opportunities for them to grow with your organization. That's, I think, also very important when you're trying to raise money.
Sure. Okay. All right, great. Joshua?
I think most of the folks who are sitting here and watching this are here because they've got an idea, and they're trying to make that idea into something more than just an idea. They're trying to make it into a business, a livelihood, a legacy. I think the points I would emphasize is there are things that you can do on the front end before you call an attorney to protect your ideas, primarily maintaining confidentiality if it's an invention or a trade secret, and taking steps like the ones I mentioned earlier, including notices on your products, obtaining relevant domain names and social media handles around your brand, but also that there's real value on the front end in investing and protecting your ideas and your brand. We worked through some of the benefits of trademark registration in particular, and we talked about the offensive and defensive benefits of a registration. I would just emphasize for folks watching to keep those ideas in mind, be thinking about the long-term viability of their company, and how the availability and the continued ability to use their mark and their brand will be key to their success going forward. So a little bit of thought, a little bit of planning and investment on the front end can go a long way in terms of ensuring the long-term viability of their businesses.
Great. Thank you very much, Joshua. Brian?
Yeah, I'll piggyback on what both of these guys said a little bit. With John, when John mentioned have your team of advisors in place, your accountants, your attorneys, really instrumental for the securities and investing aspect of this. I think it's really helpful to set up your structure with an advisor, your team of advisors in place as well. They know your situation. They know what you're going to want out of this entity after you talk to them, and that they'll help you set your structure up correctly. And then that was it, actually.
All right. Great. Well, thank you very much all for participating. I want to thank again Monroe, Moxness, and Berg. For 30 years, they've been doing legal work here in the Twin Cities as well as in the Upper Midwest and nationally. General practice law firm. To learn more about them or find bios and contact information for our three panelists, the website again is www.mmblawfirm.com. Again, thank you all for joining us.
The best lessons in life are often learned outside of the classroom. That's where all the action happens. That's where the rubber meets the road and the hard knocks knock some sense into you. But did you ever wish you could get those lessons without all the fuss? Sign up today and get your first week free. You can cancel at any time.